Taylor Swift concerts and gun bans was the subject of a Bloomberg news story, believe it or not, discussing recent court decisions by federal appellate courts explaining the notion of sensitive places, which, as you know, is a political propaganda term or euphemism for government-mandated gun-free zones. Well, Bloomberg is discussing this and discussing whether or not the current lower courts are coalescing around the notion that you can ban guns in things like Taylor Swift concerts, wherever there's a whole mess of people congregating. Well, yours truly talked in this article and is quoted in this article, and let's break down whether or not it's really true that you can ban guns in concerts and places where there's lots of people milling about. Let's chat about it when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so Mark Smith and the Four Boxes Diner appeared, believe it or not, in Bloomberg, talking about the current state of affairs as applied to the notion of sensitive places, which, as you know, is a euphemism for government-mandated gun-free zones. You see, there's an article written in Bloomberg, and I'll try to get a link to it down below. It may be behind a paywall, but that maybe gets opened up or not. We'll see, but I'll put a link to it in the description of this article, of this video anyway. The article is entitled, Taylor Swift Concerts Align Courts on Crowded Space Gun Bans. Because what's going on here is the anti-gunners are trying to argue wherever there's a lot of people around, like at a Taylor Swift concert or a zoo or some other event, then gun bans are perfectly constitutional based on American history. Now, I pointed out and made the observation to Bloomberg here that that is simply a bunch of hooey, not only historically, but also as a matter of Supreme Court precedent. So let's just break this down a little bit. Just to jog your memory, in Disarmed versus Bruin, which was decided in the summer of 2022, one of the conclusions of the court was that indeed, guess what? Everyone had a right to carry guns in public for the purposes of self-defense. That was a fundamental right. But it did indicate there may be some places that a government could deem to be a sensitive place or a government-mandated gun-free zone. There are three specific examples that the court identified were courthouses, legislative chambers, and polling places. The court said that it's possible that you could derive analogies from those three places. And again, as we've talked about on this channel before, what made those three places particularly special was the fact that they actually had security there so that you didn't have to bring your gun because someone else brought a gun to defend you, which makes a lot of sense. To take away the right to keep and bear arms can only be done, in my view, and I think this is consistent with the history of sensitive places, if someone else is going to step up and use guns to protect you in the same way that you have the government has no duty to protect you from criminals unless they take you into custody, at which point they do have a duty to protect you from criminals because they're depriving you of the ability to protect yourself because they either put you in the back of a squad car or in a prison, let's say. So with that said, let's turn back to this Bloomberg article. So really, you're going to see here a discussion summarizing how some of the lower courts are basically been upholding laws that say you can ban guns places where they are very crowded, for example. And of course, the anti-gun movement in America loves this idea. They like the idea of just pointing to say if you have a lot of people there, guns are dangerous, and therefore you get to ban them. And in my view, that is sloppy reasoning. But let's take a look at what this article has to say in the critical point, and then we're going to break it down in detail, explaining why I sort of disagree, not with the article's analysis so much, but with the court's analysis that the article is describing. Here's what the article has to say about this particular theory and where it stands today in many federal courts. Appeal courts from the conservative Fifth Circuit to the liberal Ninth Circuit have upheld location-based firearms restrictions applying a history-focused test laid out in the U.S. Supreme Court's 2022 ruling in Disarmed versus Bruin. The latest decision from the Third Circuit, issued September 10th, bolstered the theory that principles gleaned from the 18th and 19th century laws regulating sensitive places provide foundation for states to ban guns in modern-day venues like massive concerts. While our forebears may have enjoyed waltzes and ballrooms instead of Taylor Swift concerts in sports music arenas, Americans' desire for physical safety and the peace of mind during leisure has endured, forging a national tradition that supports New Jersey's ban, the court's majority said in the Third Circuit. Now, pro-regulation litigators say the ruling underlines a broader trend, mostly in liberal jurisdictions, with judges considering challenges to blue state gun regulations. Judges are coalescing around a theory that the text, history, and tradition of U.S. firearm regulations allows states to ban weapons from many public places in crowded areas like parks, zoos, beaches, and entertainment districts. Now, there's truth to what's being said there, but did you notice that critical language that the author of this article astutely pointed out? That these rulings, as a general matter, are coming about by judges in liberal jurisdictions in the blue states, which is exactly what you would expect, that anti-gun judges appointed to the bench by anti-gun politicians in anti-gun states are going to be the same ones that are upholding anti-gun laws. That is not a particularly shock there. But there's a few reasons why I think this analysis, again, the article is not wrong at all, but the analysis that some people on the anti-gun side are saying is that there's this coalescence around the theory that you can ban guns where there's a lot of people simply is not going to fly at the Supreme Court level and will not be the law of the United States long run. To begin with, there's no doubt that the U.S. Supreme Court does not care one iota about what the lower courts think. That has been proven over and over and over again. In fact, that is the point that I made in this article, and then I will give you the quote, and then we'll break down why I said what I said. Here's what I said to Bloomberg. The United States Supreme Court does not care one iota if the lower courts of appeals coalesce around any one theory that restricts the right to bear arms, said Mark W. Smith, Ave Maria School of Law professor and host of a popular Second Amendment YouTube channel. As you know, the Four Boxes Diner, folks. And that's exactly right. And why did I tell Bloomberg, and why did they quote me, that it doesn't really matter at the end of the day what these lower courts coalesce around? And there's two real reasons for this. In 2008, the U.S. Supreme Court decided District of Columbia versus Heller that says that there's an individual right to keep and bear arms. Guess what? Before 2008, every single court of appeals in the United States and all the lower courts had said there was no individual right to keep and bear arms, with the exception of one decision in the Fifth Circuit and one decision in the U.S. Court of Appeals for the D.C. Circuit. Other than those two decisions, every other federal court basically in America said there was no right to keep and bear arms. It was not an individual right. And yet the Supreme Court in Heller in 2008 did not care that the lower courts had coalesced around the notion that the right to keep and bear arms was only valid in the context of serving in a militia. That is a classic example. When it comes to the Second Amendment, the Supreme Court doesn't care one bit about what the lower courts think. The other obvious example is what happened in Nysurper versus Bruin. Specifically, prior to Bruin, which was decided in 2022, the courts in the lower courts, the courts of appeals, had coalesced around another theory that was really the two-step process. The first step is you figured out whether or not the modern-day gun control law between the year 2008 and 2022, that modern gun control law pre-Bruin, did that implicate the Second Amendment? And if the answer is yes, it implicated the Second Amendment, then they went on and did another step and basically engaged in interest balancing, strict scrutiny, intermediate scrutiny, tiers of scrutiny, whatever you want to call it. But basically they said, yes, even if the Second Amendment is implicated by a modern-day gun control law, they went ahead and balanced away your individual rights. And the U.S. Supreme Court said, you can't do that. This is exactly what the Supreme Court said in saying this is a no-go zone. Simply, this is one step too far. Again, even though the lower courts had coalesced around this two-step process, giving the government two chances to win. The first chance to say it did not violate the Second Amendment, this modern-day gun control did not violate the Second Amendment, and a second crack at the apple as the first answer was yes. Then they gave the government a chance to show that it still made sense to allow the regulation to stand because it was just some sort of interest balancing that weighed in favor of the regulation. And the Supreme Court said, no, that second step was not allowed under originalism and under the text of the Second Amendment or the history of the Second Amendment. And here's what the court had to say in rejecting the notion that even though the lower courts had coalesced around this two-step process, that they were going to follow it because that was not the law of the land. Here's what the court had to say on this point in Bruin. Since Heller and McDonald, the two-step test that courts of appeals have developed to assess Second Amendment claims proceeds as follows. At the first step, the government may justify its regulation by establishing that the challenged law regulates activity falling outside the scope of the right as originally understood. At the second step, courts then analyze how close the law comes to the core of the Second Amendment right and the severity of the law's burden on that right. The courts of appeals generally maintain that the core Second Amendment right is limited to self-defense in the home. If a core Second Amendment right is burdened, the courts apply strict scrutiny and ask whether the government can prove that law is narrowly tailored to achieve a compelling governmental interest. Otherwise, they apply intermediate scrutiny and consider whether the government can show that the regulation is substantially related to the achievement of an important interest. Now, despite the popularity in the lower courts of this two-step approach, it is one step too many. Step one of the predominant framework is broadly consistent with Heller, which demands a test rooted in the Second Amendment's text as informed by history. But Heller and McDonald do not support applying means-end scrutiny in the Second Amendment context. Exactly right. A second example, both in Heller and in Bruen, the U.S. Supreme Court literally did not care that the lower courts had coalesced around any theory. So even assuming that we care that the lower courts are coalescing around some sort of theory that says you can ban guns where there's a lot of people, like at a Taylor Swift concert, it really is not going to matter to the U.S. Supreme Court, nor should it, because historically, guess what? You can't ban guns just because there's a lot of people around. Now, you don't have to even believe me. You can look at the U.S. Supreme Court, because in Bruen itself, it specifically says that just because you have a large population with presumably some sort of generalized police protection, that is not enough to make it a sensitive place, allowing it to ban guns consistent with the Second Amendment. Here's what the Supreme Court had to say about why, for example, you cannot ban guns on the island of Manhattan simply because there's a lot of people there and presumed police presence. Here's what the Supreme Court said in Bruen on this exact topic in 2022. Although we have no occasion to comprehensively define sensitive places in this case, we do think respondents, that would be New York, err in their attempt to characterize New York's proper cause requirement as a sensitive place law. In their view, sensitive places where the government may lawfully disarm law-abiding citizens include all places where people typically congregate and where law enforcement and other public safety professionals are presumptively available. It is true that people sometimes congregate in sensitive places, and it is likewise true that the law enforcement professionals are usually presumptively available in those locations. But expanding the category of sensitive places simply to all places of public congregation that are not isolated from law enforcement defines the category of sensitive places far too broadly. New York's argument would be, in effect, to exempt cities from the Second Amendment, and it would eviscerate the general right to public carry arms for self-defense that we discuss in detail below. Put simply, there is no historical basis for New York to effectively declare the island of Manhattan a sensitive place simply because it is crowded and protected generally by the New York City Police Department. Exactly right. Just because there's a lot of people there and presumed police presence does not make something a sensitive place. Despite that, you can see the anti-gunners want to basically argue something along the lines that if you can have a Taylor Swift concert or these other things, you can ban guns simply by virtue of the fact there's a lot of people there. But the reality is it all turns on comprehensive security, which we don't need to belabor that point today, because I'm just really talking generally about how the notion the lower courts are coalescing, or I should say the lower blue courts, the blue state courts are coalescing around basically gun laws are okay. That's really what they're coalescing around. It's not a specific thing involving sensitive places. It's just a general approach that as a general matter, Bruen doesn't matter, Heller doesn't matter, and they can generally regulate guns any way they want. That is simply the attitude of most of these anti-Trump, anti-American courts that simply don't like you having guns because you're a peon, a serf, and not really a citizen, and their elitist attitudes just ooze through these opinions, as well you know, because we've been covering this for several years. Now, with that said, I just want to remind you of one historical fact that's extremely important. If you only remember one thing about this particular video, this is the one thing I'd like you to remember, and that is this. In the year of our Lord, 1770, we had the Boston Massacre, where British officers and British soldiers shot and killed 6 to 8, I can't remember the number, I think it was 8 Americans were shot and killed during the Boston Massacre of 1770. Now, what you need to remember about that is this, that American founding father John Adams, the most prominent lawyer in the state of Massachusetts at the time, represented the officer and the soldiers who were the Brits who shot and killed these American patriots. And what you need to remember about this particular story is during the opening statement in Boston, in the criminal case, Attorney John Adams, on behalf of his clients, the British officer And the soldiers specifically acknowledged that the individual Americans in the heart of Boston, because remember, the Boston Massacre occurs literally in the heart of Boston. It was the social center, the political center, the economic center, right there at the heart of Boston in 1770 is where it took place. And John Adams, the American founding father, who was involved with, of course, all the founding documents of our great government and our great country, he acknowledges that every one of those American patriots had a right to bear arms. This is what he said during the opening statement, and it's very important for you to remember this. Here, every private person is authorized to arm himself, and on the strength of this authority, I do not deny the inhabitants of Boston had a right to arm themselves at that time for their defense, but not for offense. That distinction is material and must be attended to. Now, the reason why this is so important, what John Adams said in 1770, is it goes that the original understanding was that Americans could carry guns even in places where a lot of people congregated, because at the time of our founding, there were very few places in the American colonies that were more congested with people and social and political and economic activities than that area in downtown Boston, Massachusetts, that had the old State House and all sorts of other sort of vestiges and evidence and artifacts of British authority. This was the center of Boston where the Boston Massacre occurred. And John Adams, one of the founders of our great country, literally says there's no dispute that the American patriots there that day had every right to bear arms, as long as they did so for self-defense and in a peaceable manner. And that, of course, is where he raised the defense that perhaps they acted across the line. They were acting offensively and scared and intimidated his clients, the British officer, and the soldiers, and that's why they fired in self-defense. But he acknowledges the right to keep and bear arms in a congested place, which is entirely inconsistent with this notion that just because there's a lot of people together, like at a Taylor Swift concert, that alone allows government to ban guns. That is clearly not the case, whether you look at the U.S. Supreme Court precedent of Bruin or the history of the statement of John Adams in the opening statement, his opening argument in the Boston Massacre trial back in 1770, 1771. However you want to look at this, the theory that you can ban guns where there's a lot of people, whether or not the lower courts coalesced around this in the short run or not, is not relevant, because that is clearly not the accurate answer. And I don't think it's the answer the U.S. Supreme Court will ever adopt. But of course, we need the Supreme Court to take these cases and clear this up. But I'm highly confident they will agree with Mark Smith and not this other lower court nonsense. But again, we need the Supreme Court to actually step up and take these cases, because if they don't take the cases, they can't agree with Mark Smith. But I think we're going to get some good results over the next few years. But again, the history of the future has yet to be written. Okay, folks, hope you enjoyed today's episode. Make sure you follow me on X at 4Boxes Diner. Don't forget to subscribe both to YouTube and Rumble, and I look forward to talking to you real soon here at the 4 Boxes Diner.
Orders up. Table 2A.